Again, we'll continue with internet and digital forms of communication just to finalize this thought. The challenge for societies and for authorities is whether to regulate or not to regulate. UNESCO, by the way, established a series of principles that are very important on internet. We had a conference called Connecting the Dots 2 years ago. And out of that conference, by consensus, there were 4 basic principles agreed, called the ROAM principle, roam from roaming, R-O-A-M, which stands for rights-oriented, openness, accessibility, and multi-stakeholderism. And what it means is that the perspective we have on internet should always be a human rights perspective, because there are human rights standards of freedom of expression and other fundamental freedoms that we should follow. We cannot, in the name of internet or new technologies, violate fundamental principles of everyone, including privacy, for instance. Secondly, the openness is that internet has to be at a cost and the possibility of everyone. The idea of having open resources that we can all use, especially for education, is very important. That this is the sharing of knowledge around the world. And this deals with accessibility of the internet as well. So we have to have open resources, meaning the content and the software and the use of internet, and the accessibility, meaning the connectivity. We have a big debate going on about how to increase the connectivity in the world. But we say it's not only a quantity issue, it's also a quality issue. We have to decide that if we want to fulfill the Sustainable Development Goals, beginning by goal number 1, eradication of poverty, we have to make sure that are the poor sectors of society that get to have access to internet. Of course, they probably won't have access in their homes, each one person in their home, but they could have access through libraries, through internet centers, in a collective way. But we must make sure that we're getting internet to the areas where they're needed, where they will have an impact in increasing the economic and social development of a nation. Well, they will give citizen participation to sectors that have not had it, and they will give transparency to government activities, or they will allow people to receive the information they need for their daily activities. So connectivity is a very important issue, but not as a business element, which is normally seen. It's not how many people are using internet or wireless phones, smartphones. No, connectivity is important in regards to how many sectors of society are we reaching, can actually have access to information. And finally, the multi-stakeholder dialogue. The multi-stakeholder dialogue is absolutely relevant because it means that the future of internet has to be decided in this dialogue between state authorities, those that regulate, but especially the judiciary, but also between intellectuals that have drafted the internet, that have designed the internet, or intellectuals that work in other academic fields, between civil society as a whole, those that use internet for communication and information, but also all types of NGOs that have research and activities or do advocacy in different issues, and also the business sector. The business sector that either uses internet or that develops new technologies of digital communication. All those sectors have to be involved in this planning of the policies for internet, because otherwise we will create the monopoly and the hegemony of one sector over the others. And internet is a very powerful instrument that will make very powerful any particular group that can monopolize it. So our effort is to allow everyone to participate. This is why we encourage in all societies to have what we call the IGF, the Internet Governance Forum, which exists at a global level, organized by United Nations, to have a countryside IGF, to be able to have an experience in country of multi-stakeholder dialogue. And it is here where we can bring this human rights focus and this new focus of regulation. There are interesting forms of regulation. There's some interesting examples. The Ley de Marco Civil, the law of civil framework that Brazil passed, was a great example of a multi-stakeholder dialogue that transformed itself into 10 basic principles of internet, and then they transformed it into a law that regulated but did not limit nor the use, the development, nor the content in internet, and actually guaranteed that internet would be used for basic purposes of service like education, social communication, information and news, etc. So this is an important element. And in this exercise of rights, let me mention a few of them that are very important. Internet should not be used to offend each other. And we have the question of libel, whether people are using internet to disseminate false information, accusing people of a crime, or defamation, information that affects the honor and reputation of individuals. This is also in the ICCPR. Article 19, where freedom of expression is established, also talks about the limitations and says one of the limitations is the protection of the honor and reputation of individuals. The only qualification that we make is that defamation should not be a criminal action, because we don't want to put people in jail for utilizing expression. We want civil mechanisms where a misexpression or a false fact can actually be corrected and can be ordered to be corrected by a judge, or there can be an economic sanction, but not the use of jail, because that becomes intimidating. That's an important factor. The other right that used to be used was the contempt of court. The contempt of court, and in Spanish they used to call it desacato, which has now been eradicated from Spanish-speaking countries, but was the idea of criticizing any authority of the state. If you would criticize any authority of the state, it was considered contempt. And therefore, automatically, you would land in a crime and probably land in jail. When freedom of expression is precisely for the opposite purpose, to be able to analyze public policies, to be able to criticize public policies, and to be able to talk about your public officials, to compliment it when they deserve it, or to criticize them if they're corrupt or they're making mistakes. This is freedom of expression transformed into citizenship. And this is what we should protect and we should maintain for a truly democratic society. So the crime of contempt, understood from a freedom of expression perspective, should not exist. Then we fall into privacy. Privacy is really important because internet has made our privacy weaker, whether we want it or not. In big part because much of the information that is released on the web is actually uploaded voluntarily by individuals. When you're using a social network, any network, you are also putting up your information. You agree on terms of the contract, that some people call community guidelines. I don't know what community they're talking about, but you agree on the terms of the contract. You don't know who is processing that information, where they're being stored, where that information is stored, and whether they can sell it or not, or they can send it to other uses, whether commercial or political for campaigns. But the fact is that information is flowing, which is the concept, that's where the concept of the management of big data came out of, because before we used to discriminate on what was important information and non-important. Today it's the other way around. Today everything is important. All information is preserved because all information can be processed. And if it can be processed, it can be useful. Now this brings many problems, like I said, especially in the world of privacy. Because we do have to defend the privacy of the individual, the privacy of the family, the privacy of businesses or of any association or any legal entity. This is a very relevant issue. The authorities of privacy have a much more challenging work. But also in the name of privacy, I think some mistakes are being made, like, for instance, the so-called right to be forgotten, because some people were challenging that some information could be found by using the search engine in different platforms. But the search engine is basically a facilitator of finding information that is already there, that is already in old newspapers or any other source. So there is information, yes, that should be delinked when it is actually a false information or a campaign of disinformation or has a political propaganda purpose, but it cannot so easily be used that anyone would call that the right to be forgotten, request that all information be erased because it's not convenient for them. This is part of the reflection that should be made with individuals before they upload information to the website. History cannot be erased. This is one of the principles we must have. Of course, you won't necessarily find it everywhere either, but history is history, so we must always think of what we do, what we say, but also what we upload on the net. These are important issues for judges because those are the relevant decisions that will be made. And maybe the final challenge will be the challenge of jurisdiction, which has not been solved. Because internet, in a way, is an international phenomenon. We communicate anywhere and everywhere in the world. Of course, some countries have a firewall to limit the content, to not allow it into the country. Some countries have a blackout and a switch down at certain moments, especially at moments of political crisis or when there's elections. But these issues tend to be seen as illegal from a human rights perspective because they're limiting the content from abroad if you have a firewall, or you're limiting the content if you have a switch down or a shutdown. This should not occur and should not be allowed. But where do you take these grievances? Where do you decide these matters? Where will there be a court that has this jurisprudence? This is an issue that we still have to resolve in the future.